good afternoon. And can I first start by welcoming everyone to this afternoon's webinar, in which we are looking at the EU Whistleblowing Directive, and in particular, the relevance of the directive to UK businesses, but also giving you all an update on recent changes and developments across mainland Europe. And as with always, our aim today is to make today's session as interactive and as useful to all of you listening as possible. And so we've deliberately designed today's session so that we have a panel discussion. There'll be lots of interactivity, lots of discussion, and we're going to be taking a number of questions that we've already been raised or discussed with clients and contacts, and answering those, which we hope you'll find really useful. But we really want to hear from you too. So please do type your questions into the Q&A box, which you'll see on the right-hand corner of your screen. We really do want to make today, as we said, as useful and as helpful to all of you listening who are grappling with the challenges of implementing the Whistleblowing Directive in your business. But before we get started, I wanted to introduce the team. And it's great to be joined today by a team of lawyers who are working across the Taylor Wessing offices across mainland Europe. By way of introduction, for those of you who I haven't yet met, I'm Helen Farr. I'm a partner based here in London in the employment group, and I'm a key part of the Taylor Wessing International Whistleblowing Response Team. And by way of introduction, I'm absolutely delighted to be joined this afternoon by a fantastic team of colleagues, all of whom are working on a daily basis looking at whistleblowing issues. And I'm going to start with Wolfgang Kapek, who is a partner based in our Austrian offices in Vienna. And he's also leads our team of lawyers, employment lawyers, that are based across the CEE region. So I'm going to ask Wolfgang to wave and say hello to everyone, if that's possible. So hi, Wolfgang.
Hello.
Hi. Hello.
Hello.
Great.
Thanks for the intro, Helen.
Thanks for joining us, Wolfgang. And without sounding too much like the Eurovision contest, we have from Germany, we've got Jan Patrick Vogel, who is a partner based in our Frankfurt office. So Jan, if you could also say hello, that would be great.
Hello, everybody. Thanks, Helen.
Great. Thanks, Jan. And last but by absolutely no means least, we have Marie Michaud-Neral, who's based in our offices in Belgium. And Marie is also a key part of our whistleblowing offering, and she will be talking about the position, obviously, in Belgium and also in the Netherlands too. So I'm going to ask Marie if you could just quickly say hello to.
Hello.
That would be great.
Hello, I'm Marie.
Hi.
Thank you for the introduction.
Thanks. Brilliant. So what are we going to cover today? Well, as I've said, what we're going to be doing is I'm going to give a very short overview, really by way of a reminder for those of you listening, or an introduction for those of you who are coming to this completely new, about what is changing with the introduction of the directive. Then we're going to deal with a panel session where we're going to discuss and debate some of those issues in practice and how you can manage those in your business. But then we've also going to be allowing lots of time for questions. So as I said, please do put your questions in the Q&A chat box, because it would be fantastic to hear from you. As with always, I'm conscious that we are due to finish in an hour, and we will be ending the session promptly at the allocated time. So without further ado, I'm going to start just by reminding you about the key requirements of the Whistleblowing Directive. Now, the Whistleblowing Directive was introduced by the EU as a result of the fallout from a number of scandals which show how important whistleblowers, their importance and their role that they play in revealing wrongdoing. And so examples of those would be the Panama Papers scandal, which highlighted tax avoidance, through to the Cambridge Analytica disclosures, which showed how the company Cambridge Analytica was misusing personal data. And as such, the EU directive aims to set out a key level of minimum protection or minimum standards that will apply across Europe to protect whistleblowers and to support them if they are involved or aware of a situation that means that they should be disclosing wrongdoing. And the key requirements of the directive are as follows. And the first deals with the reporting requirements. And we have these new reporting requirements introduced, which apply at the moment to those with more than 250 workers in their business. So that's a broad, and the definition of workers is the broadest one. So it's not just employees, in that they are expected to introduce and have in place a secure internal reporting channel that enables whistleblowers' confidentiality to be protected. From the 17th of December 2023, that requirement will apply to businesses with 50 or more workers. There's also needs to be in every member state a system where whistleblowers can report their concerns to either national or EU authorities and encouraged to do that. And public reporting is also to be supported. So that would be to the press or to other public disclosures. And the choice as to where the report is made is very much left to the whistleblower. There's also requirements that the whistleblower needs to be kept confidential, and that the whistleblower has to be updated about the status of the disclosure that they've made. The expectation is that the disclosure will be acknowledged within 7 days, and that an employer will provide feedback within 3 months, or a reasonable time frame that should not exceed 3 months. And of course, the most important area from the whistleblower's perspective is that they must be protected from retaliatory action. So, for example, an employer must not take steps to subject the whistleblower to detrimental treatment, perhaps, a pay cut, or even being sacked. And there should be and must be an effective system of remedies and penalties that will be imposed against businesses that take steps. And in many ways, that mirrors the system that those of you listening based in the UK will be familiar with. But of course, this new system and we're seeing that it does pose various challenges for businesses. And they include the system of how, or the question really, of how should you introduce the new directive? What should employers do? Should they be expected to have everyone across Europe all working to the same standard? And this is a problem because what we're seeing, and we're going to be coming on to discuss this, is that there is a real divergence in approach between the various member states. So the question for employers is, if they have a team based in a number of countries across mainland Europe, how do they manage that? Do they level up everyone, or do they keep everyone at their own local levels? How do they establish a reporting channel? We've seen that the expectation is it has to be secure. It has to be a system where the whistleblower's confidentiality is protected and can't be uncovered. So we'll be talking about that in our panel discussion. You need to take steps to educate and train your staff. For many jurisdictions, it's a new issue, and so managers and workers need to be trained. And of course, those working in control functions like HR, compliance, and legal need to understand what the new system is and to be able to introduce it effectively. And last but no means least, what we're also seeing is companies are expected to introduce new policies and procedures across their business to reflect these changes. So absolutely lots of issues for you all to to deal with. And with that introduction, I'm going to start our formal panel discussion. So we're going to look at by asking some questions about the legal framework. And as I alluded to, what we've seen is that the implementation of the directive has been delayed across certain member states. The directive should have been introduced on the 17th of December last year, so 2021, but that's certainly not the case. And what we're often asked is what's the best way for companies to track the implementation status of the directive across member states? And Marie, I wondered if you could give those listening some guidance on that issue and what they should do. Oh, I think you might still be on mute, Marie.
Sorry, all my apologies. Yeah. I'm there. Thank you, Helen, for giving me the question. We have, of course, some guidance regarding the fact to check and to know how it's going on in the EU countries regarding the implementation of the directive. And something very important to know is there's a very interesting website to check it. And the website is the Whistleblowing Monitor.eu. This website has been organized by 3 major organizations. Eurocadre is an European Union organization. You have the Whistleblowing International Network, which is a non-profit organization based in the UK. And you have also the Transparency International EU organization, who has been organized this website. And I will recall, the name of the website is the Whistleblowing Monitor.eu. And what can you find there? You can find a very interesting chart where they have been mentioned, and this mentioned with updated information about each country. And what you can find there is information about how and where we are in the implementation of the directive for every country. And for me, what is also important, when we have such initiative, it's more than a year ago, you will think maybe there will not be a follow-up and things like that. But if you look at this, you will see that for example, France, we haven't updated in this month. Now, I will, really suggest for all our viewers to check at first this website to know what is the status of the implementation for every country. Next to this, very important, this website only gives you a global overview, a global information. If you have activities in some of the EU countries, I will say, you need to contact your local legal advisor to make sure that what you want to do, it's okay in compliance with the directive, but of course with the national law, and to make sure that, every step that you will take will be in accordance with, national law. And for me, it's very important to repeat this.
Thanks, Marie. And we will be circulating the details of that website to everyone who's listening, because I know that that's a really useful resource for everyone. Now, again, obviously, as well as tracking the implementation dates, it's also really helpful to understand what's happening in each country. And interestingly, the position in Germany, a lot of us have been watching and waiting to see what's happening in Germany because they've delayed implementation, and it's still not yet. The directive has still not been introduced there, despite it being very much sort of something that's been debated. And Jan, I understand now that we've got some interesting news, which is that the German draft is progressing. and that the position is that the draft is due to be discussed in Parliament tonight. You were saying earlier that it's going to be discussed at 10 o'clock this evening, so obviously quite a late night for those sitting in Parliament. But it'd be great to get an update on the status as to what's happening in Germany specifically, because I know that will be relevant to lots of people watching. And also to understand, whether you think that hopefully this draft will be it, or whether we're expecting much more changes. Oh, I think, Jan, you're also on mute.
Good.
Thank you.
Yeah, thank you, Helen, for both the introduction and saying that I'm muted. It is as it happens. We have the German draft on the floor in Parliament tonight at 10 o'clock. There's a live stream. You can watch it if you're interested. And the expectation in Germany is that the draft, as we know him right now, will not be changed during the parliamentary process. It will stay more or less the same. I just give you from my perspective, three most important issues that we have in Germany is that we have these very strict confidentiality obligations in the draft. We have these very, very high fines for not implementing proper whistleblowing systems or violating the confidentiality. It is possible to get a 1 million fine for violating confidentiality obligations within the whistleblowing channel. So this is very important. And I'm pretty sure that this will not be changed in the parliamentary process.
Brilliant. Oh, that's helpful, and it's also helpful to know because that's a significant fine, isn't it? That's quite a high level. So businesses do need to be aware of that. Wolfgang, are you able to comment on the position in other jurisdictions?
Yes, thanks, Helen. As of today, and what we can also see from this monitor, which is very helpful, only 11 countries have passed respective laws. This includes Denmark, Sweden, Portugal, Lithuania, Malta, Cyprus, Latvia, France, Croatia, Romania, and Ireland. And then about 10 have drafts prepared. The others are only on their way. This website says, for example, as I'm talking about CEE, Hungary has not even started. Might be true or might not be true, but at least there is no draft or law at this time. Austria is also late. Unfortunately, we, for example, had a draft bill in the summer, which was then reviewed by all parties involved. So far, we didn't hear anything back, but we are very keen to get it, of course. I mean, one might remember it was December last year when all these transitions should have been finalized. Other than Germany, in Austria, for example, and this was discussed very heavily, there would be no fine for not implementing an internal reporting system. But many people said, okay, does this law make any sense at all? But we will see what we will get here in Austria. Mm-hmm. But Helen, what I'm wondering is now that some laws were already adopted and others are to come, will there be a review of the UK law already in place and related to the protection of whistleblowers to ensure that the UK employees have the same level of protection?
Yeah, thanks, Wolfgang. And that's something that we're being asked a lot about in the UK. Will our current system change? And I think the short answer to that is probably not. The reason is that there's no obligation on the UK government to change the law or to transpose the Whistleblowing Directive into UK law now that we've obviously taken the decision to leave and to Brexit. But we do have a number of the same level of protection in the UK legal framework. And it does give those working in the UK many of the same level of protections. In fact, quite a lot of the Whistleblowing Directive does mirror the system that we already have in the UK. And in that way, actually in the UK, we're quite advanced in comparison to other countries. So, for example, in the UK, we have provision that whistleblowers can't be subject to detrimental treatment, which is a key pillar of the directive, and also, of course, from being dismissed, which is fundamental. But there's also wider protection in the UK about the scope of activities that whistleblower can report. So, for example, under the directive, there's quite a limited list of protected concerns that apply to specific areas like protecting the environment or transport safety. Of course, it's down to countries if they want to expand on that list. But in the UK, we have a wider hurdle. So basically, any breach of a legal obligation is okay to get protection. But having said that, what I would just say, so for those listening who are based in the UK but have a footprint in the EU or are operating in the EU, if you do have an EU branch or people working in the EU, even under a UK contract of employment, then you may well find that you are still in scope for those employees to comply with the directive. And so you do still need to be aware of the directive's requirements, and in particular to think about putting in place that secure reporting channel, which is a fundamental part of the directive's requirements. And so you can see, I think, from those listening, that really the Whistleblowing Directive, one of the key principles is to ensure that there is a level playing field between the standards that apply across Europe. So, Jan, I've got another question for you, which is about the period in which a company has to respond. And we had a question from a client who asked about the position when a whistleblowing complaint is received before the EU directive comes into effect. And the question was whether that 3-month time period to provide a response would start on the date when the directive comes into effect in your country, or would earlier complaints sort of just fall outside the scope of the directive altogether, even if they're not resolved at the time when the directive comes into force? And I guess that could be an issue for those listening, in particular in Germany, given that the directive isn't yet in force in Germany. Oh, I think you might still be on mute. I don't know what's happening.
I don't know. I think the reason is me. I always forgot to unmute me. But thank you, Ellen. I was just thinking and saying that it is a very good question and a very interesting question. For Germany, the good thing is it doesn't matter, because in Germany you have a 3-month period between the adoption of the law. The companies have 3 months time to implement their whistleblowing system. So this old case scenario is unapplicable for German law. I would say the old cases, they will fall into the scope of the European whistleblowing direction once the national law has come to in place. But as Marie said, it very much depends on the countries. So you need to, if you are a global company, if you are multinational, you need to contact your local council and ask them whether in the countries and in the jurisdictions are same rules as in Germany, with these 3 months time frame to adopt the law then.
Okay, thank you. And if because I think for many businesses, they're really attracted by this idea of actually trying to harmonise and have the same system across all of their companies in mainland Europe, because it's just so difficult to have 5 or more different unique systems. And Wolfgang, I suppose another question which comes up quite a lot is, can you have all whistleblowing complaints dealt with by your head office? So say you have a head office in Austria or Vienna, that it applies to everyone, all of the subsidiaries across Europe. Is it possible to have the complaints dealt with by someone in that head office, or does it have to be someone? Does each country have to have their own separate system to deal with whistleblowing complaints under this new regime?
That is, I would say, maybe one of the most discussed points, as far as we can see in all the countries, and the answers are unfortunately different. It is there seems to be a quite common understanding that for companies with less than 250 employees, it is possible to have, let's say, joint internal positions who take care of the complaints. For bigger companies, there is a broad discussion going on, and even the Commission said they believe it's not possible. However, we know, for example, that the Northern European countries just implemented laws saying that it is possible. The Austrian draft, we would read in a way, for example, that it is possible. However, in the comments to it, some people already said it's not expressly in there, so it might not be possible. I think this will really be one of the biggest challenges to find out if this is okay or if it's not okay. And further on, it also gets down to the question, can I do it in one country with more subsidiaries in the same country? So it's not even only the question if I go cross-border, but even within the same country. I mean, and that's very problematic. So we were very happy to see that in our view, the Austrian draft said it's possible. And I hope it will be adopted this way. But yeah, it is a big issue.
Mm-hmm. Yeah. Okay. I don't know. I mean, certainly from a UK perspective, there is no sort of. I mean, it's slightly easier. So you could, in theory, have your if you wanted to include complaints based or made by UK employees. To have those complaints dealt with by someone based in mainland Europe, that would be possible. In most sectors other than in financial services, there are some specific rules that apply because they're regulated in the UK, but in most sectors you could do that in the UK, so it's an option here. But as I said, you do just need to make sure, I would say, that anyone who's dealing with the complaint does have an understanding of the kind of local regime as well, so that they protect the confidentiality of the whistleblower and they don't fall foul of any local rules. I don't know, Jan, is there any clarity on the position with Germany in terms of whether what the expectation is for Germany, whether it can be dealt with in any country, or whether the position seems to be that whistleblowing complaints made by a German employee would have to be dealt with in Germany too? Oh, sorry, could you come off mute again? I'm going to be there.
I think that in the first times I have learned it on my own. Thank you, Ellen. I would say that the German perspective is that you can use centralized systems. Yeah, and of course, a German employee based in Germany can use the system from the UK or can use the system from the US. But the big but is then the UK system or the US system needs to comply with German law, and especially when it comes to data protection law. Yeah, and if you have a UK system or you have a US whistleblowing system, then personal data is transferred to the US or to the UK. So you have to make sure that this is within the line and within the German law or the European law. And if this is the case, then the German employee can, of course, use the international system, sure. But you need to adopt the international policies to the German or to the Belgium or to the Austrian standards, which we are doing such rollout projects. We try to adopt as little as possible to the national requirements.
Okay. Yeah, that's brilliant. Thank you. That's really helpful. And that's a great point as well that you've made about thinking about transferring data between countries as well, because that's really important to make sure that's compliant.
If I can add something about Belgium.
Yeah, please do.
About the problematic to have, a general system for more than 250 employees. Today, we don't have this possibility for Belgium, okay? We have been limited to what the directive has said. We don't have a broader scope. When I heard that, Austria and Germany is going further than what we can read in the directive, we don't have the same thing in Belgium and also in the Netherlands. That's very important to mention. And things for me very important to mention also is that in Belgium, we are, dealing with different languages. And the languages in Belgium are very, very important related to the employment matters, because you need to speak and to use the language of the employee, depending where he's working and so on. There's very, very, very strict regulation regarding, the language you use. And as you will, there's some very nice system that you can buy, and they can translate everything, and you can use different language to send you your complaint. But for me, what is very important to mention is that the person who will receive the complaint need to understand and need to be able to answer in the same language. Because if you have translation in another way, it can be that you don't have the same result and the same quality of language at the end. That's it.
Thank you. Thanks, Marie. That's really, really helpful. And a question that often comes up, especially when we're thinking about how we apply the directive, is if you're a UK business with a subsidiary in the EU and it's got less than 50 employees, would you still be impacted by the EU directive?
So, first time, I unmuted myself, Helen, as promised.
Thank you.
I would say yes, of course. No, of course not. Yeah, if you have below 50 from a German or European Union standard, you're not obligated. You're not obligated to have a whistleblowing system which complies with all these regulations. So if you're below the threshold, then it might be a different question whether it is useful to have a whistleblowing system or not. But from my perspective, you are more freely how this whistleblowing system looks like. Because let's not forget, the European Whistleblowing Directive is not saying just you need a whistleblowing system. It's much more sophisticated, with these kind of deadlines you have and with this kind of obligation to keep the whistleblower and all other people involved confidential, which is very, very difficult in internal investigations to keep these confidentiality. So if you have below 50 person in a jurisdiction, then you're out. You don't need to do that. Another question is, if you do it nevertheless, and if you do that although you have below 50, then one can ask oneself, does the regulation then nevertheless apply? But this is a different question. But you're not obligated. The threshold is clear, and in many jurisdictions, there is 1 year in which the threshold is 250 employees. For Germany, for example, the 50 threshold just kicks in 2023, not in 2022.
Yeah, no, that's right. And I think that's the same position everywhere. But I think, so Wolfgang, did you want to add anything there?
Sorry. I just wanted to add something because I absolutely in line with what Jan said. The only thing is, what we shouldn't forget is that the protection is still given. So the retaliation measures you can't set against someone, even if you have only 5 employees, because he could still go and use an external channel with the authority if you don't have an internal one. And then you have to safeguard all these protective measures, because there is no threshold for these, only for the implementation of an internal system. So you shouldn't say that someone's fired because he filed some complaint somewhere.
Yeah,
Yeah,
great advice.
absolutely.
Thanks, Wolfgang. That's great. And Wolfgang, a question for you. We've also had a lot of questions about how you assess that, the 50 to 150 threshold. Can you assess that at a group level? So if you have, say, 3 or 4 companies across Europe, perhaps with, less than 250 in each, but together would make 250, are you then caught by this obligation to have the whistleblowing secured helpline or reporting channel, or is it okay just to assess each company on an individual basis? Are you able to clarify that?
Yes, to how we read the directive, and for example, also at least the Austrian draft, it is very clear that the threshold is in place with regard to the specific legal entity. So it's not a group. You don't look at the whole group, but you look at the specific legal entity in the respective country. Of course, there will be some questions, for example, with leased employees, which in my opinion will count. But in principle, it is the legal entity which is the basis.
Yeah, and I think that's great, because it does make it easier for especially smaller employers, because at the moment they're not going to meet the 250 threshold.
Yeah, that's the only caveat, because every time you think something's easy, someone comes up and says it's different, as we know.
Yeah.
But the wording is clear. And
okay,
I would say it's not the group.
That's great. Thank you.
So, but Helen, may I give back a question? I mean, what would you think from from a UK perspective, and knowing that there might be many people in the audience who have UK headquarters? Would it be good to have one whistleblowing framework and policy across all jurisdictions? So maybe, as Jan said, then just adopt a little bit. Or what's your position on this?
Well, I think it's certainly an option that employers should consider, because it makes sense, I think, from an employee relations perspective, to treat all your employees in the same group in the same way. It sort of avoids any argument about difference in treatment, and it also is much more simple for management and HR and legal and compliance to operate. But there are, I think, some issues. There's always a but, isn't there, when we're giving advice. And I think the first piece of advice is, as I hope will become clear, that the position is very different in each of the member states. And what we're seeing is, a difference in approach between the different jurisdictions. And of course, obviously, the position in the UK is different too. So what you do need to think about is, I think, doing some kind of a risk-based assessment. So look at the position in each jurisdiction and understand whether it does make commercial sense to perhaps give people a slightly higher standard of protection than they would qualify for under the legal regime, to bring them up in line with colleagues in a different jurisdiction. And of course, there's going to be cost implications if you want to do that. But I do think that it would make sense to introduce some parts of the directive's requirements across all jurisdictions. And in particular, what seems to make sense is that if you have if you've invested in putting in place a secure reporting channel, And it would be good to actually have that system in all of your jurisdictions across Europe, even if maybe in a couple of them the 50 limit hasn't been reached, or in the UK where it probably isn't strictly speaking a requirement at all, just because it seems to me that that's a great way to ensure compliance with the legislation generally. And it is a really good tool that employees will find helpful and will ensure that people do speak up and speak out about their concerns. But on that topic of whistleblowing hotlines, Wolfgang, if you've already got a whistleblowing hotline that's been set up with an external provider, and we know there's a number of them in the market, is that okay? Because the directive, and we've had a lot of questions from clients about this, because the directive seems to state that the whistleblowing report or concerns need to be investigated by an internal team or received internally. Is it a problem using an external provider to set up your secure channel?
Mm-hmm. I mean, to what we have seen on the market, regularly the external provider only puts in place the platform, so the technical system for the notifications and for the complaints. I would not see a problem neither under the directive nor under the laws I've seen to use here an external technical provider. What might be different is if you really do an outsourcing of the whole internal reporting channel and have someone also then doing the investigations, giving feedback to the whistleblower and all this stuff. This will in many countries be allowed, what I've seen. So I think in Germany there already are some ombudsman, I think they call them. I think I already heard this term in English, but I'm not sure. Like yes, the kindergarten. Yeah. So this would be possible, but only having this platform in place shouldn't be a problem at all. And what we also know is that some of these platforms can be tailored, given then if you need to have only local people being able to receive local complaints. So you can have an international platform, and then let's say the German compliance officer gets the German complaints, the French compliance officer gets the French ones, and so on, so that they can be adopted.
Thanks. Thanks. That's really helpful. I'm going to move because we've got some questions coming into the chat box, and we can go back to some of the questions or the points that we were going to discuss. But I just wanted to, because of time, look at a question that we've had because we're talking about implementing the directive, and this relates to the provision of a whistleblowing procedure. And the question is that in France, the provision about a whistleblowing procedure must be included in the internal rules. So the Règlement intérieur, which I think is the sort of the equivalent of a staff handbook in the UK, and they're asking whether there's a similar legal requirement in countries where a law has been passed, so where the directive has been implemented, or is it okay just to reference the whistleblowing procedure on the corporate internet? Is there any thoughts on that from anyone? I don't know, Marie, Wolfgang, Jan, if you've got any thoughts on that.
Yeah, for Belgium, I must say it will not have. We have what we call a règlement travail. That's a similar document that règlement intérieur, but it will not be included. We know already that it will be sufficient to have an outside information provided on the website or sent by email will be sufficient for Belgium. That's for me important to mention.
Okay.
Yeah, we don't even have such internal rules, or there is no need to have this here in Austria. What you might have in some also of the other CE countries and in Germany is that you might need a shop agreement or a plant bargaining agreement, so an agreement with the Works Council on implementing it. But I think also in Germany there's no need for really internal rules or a staff handbook or something like this. So.
No, not as, absolutely. Yeah, what you from compliance, general compliance obligations. Many companies have code of conduct or like, and it does make sense to incorporate the whistleblowing procedure in these kind of guidelines, but there is no legal obligation to do so. Yeah.
Okay, and I think from the UK perspective, there's no, again, normally we do have a whistleblowing policy in our staff handbook, but it's really a matter of good practice. So it's sort of set, there's no mandatory requirement to have a whistleblowing policy. But I think most responsible employers would do that because they want to signpost employees to the best way to report the concerns, and they want to make it clear that they would treat concerns appropriately. And to get to Wolfgang's point that managers can't sack people who make complaints because they're a whistleblower. So to make that really clear that the company's approach is to comply with the law. So thanks very much for asking that question. I wanted to just go back to a question about hotlines again, because it seems to be quite an interesting one. And Marie, I don't know if you can help with this one. Would it be allowed for a UK company to share their platform with other companies in the EU or the UK rather than setting up their own separate platform? So can you have the same platform? It's kind of a similar question, I suppose, to the one we had earlier.
Yeah. We don't have really a straight answer. Jan, mentioned it earlier. If we have a platform which will be compliant with, the directive and with the national law, I will say, why not? But the only thing is that if you share, you need to make sure that it's in compliance with every EU law which will be applicable to the platform. I think, good practice will be to have a share resources. That's right. But at the end, I think it will be very difficult. And, I will say also when we speak about Germany and Austria about, the collective bargaining agreement, they could be, in Belgium, it could be the rule to go that way. And if you need to go to consultation with Work Council, that it will take more time. And if you want to have one big system, you will not wait for implementation in Belgium, and Germany is waiting and UK is waiting. I think it depends from country to country, from company to company, and it will be, it will be maybe possible, but maybe also not.
Okay, thank you. Now, I'm going to move to a question that's come in from the audience. So thanks very much. Please keep these coming. And this is a question which is asking, in certain third countries outside of the EU, there are only laws pertaining to the protection of persons who report corruption, providing similar protection system to such persons as the whistleblowers set up with the relevant EU directive. And the point is that the term corruption is defined to encompass abuse of authorities in both the private and public sector with the aim of gaining an advantage. And so the point is, can we conclude that this protection of corruption, or those who report concerns about corruptions, covers only a part of the whistleblowing protection as set under the EU directive? Wolfgang, you've got your hand up. Yes, please do.
Yeah. I mean, the funny thing is that anti-corruption is not even a part of the EU directive.
Yeah.
It is also a discussion in all the countries if there is a broader scope implemented than it is in the EU directive. The thing is not that the EU is not interested in anti-corruption, I would say, but it is just a fact that, let's say, local corruption and all these things is not in the scope of the EU. So the directive could not say you have to implement anti-corruption laws and so on. Mm-hmm. For example, in Austria, the draft implements it, but this is also under discussion. We also know that some other countries only stick to what the EU says to any breaches of European Union law. So again, I would say, it's even something different. Maybe I would assume that many countries will implement also the whole thing of anti-corruption laws, but you have to look it up in every country.
Yeah, exactly. To give, in addition for Belgium, we have tax evasion and tax fraud will be included.
Okay.
When you speak about the scope.
Yeah.
I mean, the scope, if I may add here, is a big arguing topic also in Germany. I mean, what can companies do? Because as Wolfgang said, the directive just says EU law. I mean, we are four lawyers here, and I can only speak for myself, but I couldn't tell on each and everything which is EU law and which is national law. So how can a potential whistleblower differentiate when he's protected and or she and when not? Yeah. So this is difficult. So a good advice for companies would be just to broaden it up. Yeah. And I mean, a whistleblowing tool is a useful tool for compliance because it makes it possible that you might see violations of the law in your company before the prosecutor does. So what is probably a good advice is that you broaden it up the scope in your own company policy for criminal law, anti-corruption, and other discrimination stuff.
Yeah, no, I would agree with that. And certainly the position in the UK is we've adopted in UK law is that any breach of a legal obligation, you would get protection. You would be protected for making complaints about any breach. But I'm just conscious we've got another question seems to be coming in, which is fantastic. We've got some more coming through. The next question is, we are a company based in an EU member state, and we have subsidiaries based in other member states, but other subsidiaries are based in China or the USA. And they've said, is the implementation of a group whistleblowing channel enough to be in compliance with the requirements of the EU Whistleblowing Directive? And I assume by that they mean a channel that would apply to both the EU and the non-EU member states. Wolfgang, I think you kind of touched on that a little bit earlier, didn't you?
Yes, I mean, if it's made up in the European Union and tailored to the specific needs of the respective member states, what Jan already said, that you always have to, of course, take a look and maybe do some adoptions. Then it will be fine for the European Union. Again, you have to take a close look if it can be, let's say, only the headquarter who deals with every complaint, or if you need to confer some of those to the local entities. But in principle, you can do a group-wide implementation. However, I cannot say if this then is also fine for the US and China. This would need to be looked at very closely if you can implement also US employees or employees you might have in China into an EU system. I mean, it wouldn't be a problem from the EU perspective, but if it's then enough from the Chinese or US perspective is something to look at closely.
Okay, thanks. That's really helpful. And then we've got another question, which is, can you detail what are the sanctions in each country if the whistleblowing system is not implemented by companies?
I can start with Germany because the draft is 20,000 euros fine for the company if you have not implemented it. That's the maximum fine. And another indirect sanctions. Yeah, if you don't have a proper whistleblowing system, you can lose know-how. Yeah, then if you don't have a proper reporting line, then each and every employee is entitled to disclose know-how to any other one. So this is something which should not be underestimated.
Yes, if I might add from the Austrian perspective, I said it before that our draft didn't have any fine on non-implementation of an internal line. However, this also needs to be discussed with regard to managerial duties. And if not having a compliance system, there's already a judgment from Germany which says then the managing director becomes personally liable if something happens. Yeah. And I would say the same will apply here. So first reaction would be fine. We don't have a fine in Austria, so just let's do it. But then if you look at it, and as Jan said, you can lose know-how, and it could be that you lose a possibility, for example, to take a first step in order to protect the company's interests if you don't have an internal system and someone goes out directly to the authority or to the press. So I think looking at the fine, which is in law, is only a first step. But you need to be aware that you could become liable if you don't implement it, if there is a law which says in principle you have to.
Yeah. And Marie, what would your view be?
Yeah, it's the same in Belgium. It's like in Austria. We don't have any fine mentioned today. That we could be, in a comfort zone. But I would say you need to keep in mind that if you don't comply with the directive, the court could decide to have it, a direct effect in the country, and say to you that you need to comply with some fine at the end, and that's the thing. It can happen if you don't comply on time. I think for me it's quite sensitive, and I would say, as Jan said, that I would say everyone needs to do something, and I would say it's not because you don't have 50 employees that you don't need to do anything. I would say everyone needs to do his part in this whistleblowing system to make sure that we are living in a better living world, I think. But the big difference must be, as Jan mentioned, is if you go on the threshold and you are only with 45 people, to make sure that it's internal rules, and these internal rules are not compulsory and will not go to difficulties with employee at the end, because I can see this in some of my, litigation problem, that if you have internal rules, the employee will say to you, but you didn't put all your efforts to put it right, and to try to have a compensation and damages for this, and for internal system, not with the directive.
Thank you. I mean, I think just quickly from the UK, obviously, there's no other, unless you're working in a financial services business, there's no need to have a secure reporting line at all. But what I would say is that across the EU, and also the position in the UK is the same, that we have that the expectation is that there will be a system where, employees should be able to make complaints to external bodies or the member state, and also to go to the press and get protection. And I know certainly from a UK perspective, whenever I've been talking to clients about it, they would very much prefer to be able to deal with the issue internally than to have it going outside the business, so that they can deal with it appropriately and, resolve things. So I think that's another very good reason, even if there's no fine per se. But I just wanted to, I'm conscious we've actually hit our allocated time, and it's thank you all very much for listening to all of us. If you do have any issues or would like to discuss any concerns about whistleblowing, how to implement the directive either in one jurisdiction or across jurisdictions, please do reach out to Jan, Wolfgang, Marie and I, and we'd be delighted to help you. And we do have information about our whistleblowing service and how we can help clients, which we'll send you following this presentation. But I hope that you've all found it really interesting. If anyone else has more questions that we didn't have time to answer, please do email any one of us or all of us, and we'd be delighted to help. Thanks very much, and we very much look forward to welcoming you to another Tailing Wessing event soon. Thank you, and goodbye.
Thank you very much.
Thanks.